So this week in U.S. history, we have been looking at putting the Constitution into practice. Okay, we talked about in the first lesson the presidency of George Washington. He's the first president under the Constitution. And he sets the stage with all these precedents that other presidents are going to follow. The fact that he gives a State of the Union address, the fact that he chooses a cabinet to help advise him on certain issues, the fact that he only served 2 consecutive terms. We're going to see other presidents do that. We also talked about the fact that once he leaves office, that's when we see the development of 2 political parties, the Federalist Party and the Democratic Republicans. Then we talked about the presidency of Thomas Jefferson. Jefferson's known as the expansionist president. He's elected in 1800. It's the first peaceful transition from one political party to the next because Washington and Adams, who was president number 2, were Federalists, and Jefferson is a Democratic Republican. So we switch between the parties without any riots or revolution going on. Of course, Jefferson authorizes the Louisiana Purchase from France. We buy the Louisiana Territory, which gives us all the land west of the Mississippi to the Rocky Mountains. Lewis and Clark go out there to explore the new territory. They keep pushing past the Rockies all the way to the Pacific Ocean, to the Pacific coast, the west coast of the United States, with the help of Sacagawea, the Shoshone woman who is their guide. And we talked about that's going to double the size of the United States overnight. Then today in this last lesson, what we're going to be looking at are 3 key Supreme Court cases that are expanding the power of the judicial branch, particularly the national judicial branch and the Supreme Court. Now, there is a set of notes that goes along with this. There's a little chart that you're going to fill out. So please have that chart up as we go through these notes and we talk about these 3 cases and how they represent an expansion in political power for the judicial branch, okay? Now, it's interesting that we talk about the Supreme Court because this is the branch that probably people have the least knowledge of and the least experience with. It often gets overlooked, and it's important to remember that it does have equal footing with the other 2 branches, the executive branch and the legislative branch, and that there are checks and balances between all 3 to make sure one is not dominating the other 2. So this is on par with the executive branch and the legislative branch. And that is due in part to the work of John Marshall. Okay, these Supreme Court cases are going to help shape the power of the national government, especially the judicial branch. And it has to do with the work of Chief Justice John Marshall. He is really going to work to increase the power of the Supreme Court. Okay, and up on the top of the chart there's some fill in the blanks, and this is what you're going to put in there. Okay, we're increasing the power of the national government, especially the judicial branch, thanks to the work of Chief Justice John Marshall. Okay, now what cases are we dealing with? All right, the first one is Marbury versus Madison. Okay, now under the who box right there, you've got 2 key people. You have William Marbury, who is a judge, and you have James Madison, who is Secretary of State. Okay, now this ruling comes in 1803, but it has to deal with an issue in 1801. Okay, here's the problem. James Madison, who is the incoming Secretary of State, will not recognize William Marbury as a judge of the court. Okay, he's actually going to be a judge in the District of Columbia. Okay, now here's the background to the case. John Adams, who was the outgoing president, made a bunch of appointments before he left office. One of these was William Marbury. Okay, he promised Marbury that he was going to be Justice of the District of Columbia. Okay, well, Marbury's not supposed to take office until after Adams has left, and Madison, who is part of Thomas Jefferson's cabinet, coming in says, no, I'm not going to give Marbury the appointment. We didn't make the appointment. Why should we have to accept him as judge in the District of Columbia? We really have no idea who this guy is. The only thing we know about him is he's a Federalist, which is why Adams appointed him in the first place. So we are not going to sit Marbury in the court, okay? And of course, Marbury sues. All right, Marbury sues for his position. He says, nope, I was promised that. I'm going to be a judge. Well, in looking over the situation, Chief Justice Marshall says it is unconstitutional for a new president to recognize appointments from a previous president. Okay, that had to do with something called the Judiciary Act of 1789. The Judiciary Act of 1789 basically said incoming presidents have to accept the appointments of outgoing presidents. Okay, and Jefferson and Madison said, no, I don't think this is right. And what the courts do is they go back and they look at that Judiciary Act of 1789, and Marshall in the court says, you know what? That's right. That is unconstitutional. An incoming president should not be forced to recognize the appointments of the outgoing president. What this establishes is something called judicial review. Judicial review is the power of the court to declare a law unconstitutional. Okay, you cannot require the government official to perform a specific duty. That's unconstitutional. Okay, so the fact that we go back, not only is the law unconstitutional, but the fact that the court goes back and says it's unconstitutional, that is a big deal. And that is the power of judicial review. Okay, now the second case here is McCulloch versus Maryland. Okay, McCulloch versus Maryland occurs in 1809. You have two people. You have James McCulloch, who's a bank manager, and the state of Maryland. Okay, now this has to do with the renewal of the Bank of the United States. Now remember, the Bank of the United States was created during Washington's presidency. Well, it is up for renewal every so often. Okay, and the bank is getting renewed, and there are going to be a bunch of these national banks established in states around the country. Well, the state banks don't like that, okay, because that means the national bank is going to take money and take business away from the state banks, and the state banks want to exist as well. So one of these national banks is going to pop up in Maryland. And Maryland says, the state of Maryland says, okay, to protect our Maryland banks, we're going to tax the national bank. If you do business with the national bank, you're going to pay a tax. Okay, that's the problem. All right, Maryland has decided to tax bank business. All right, and McCulloch, who is the manager of the national bank in Maryland, refuses to pay the tax. Okay, and Maryland says, well, that's not fair. You can't refuse to pay the tax, so we're going to sue you. All right, so that's the background of this: is you have the national bank versus state banks. The state decides to protect its banks. We're going to tax the national bank. We're going to tax business in the national bank. The bank manager, James McCulloch, says, you can't do that. I'm not going to pay your taxes. And Maryland sues. Again, we see some of that tension between the power of the national government and the power of the state governments. Well, in the decision, the Supreme Court says a state cannot tax the federal government. Okay, states cannot tax the federal government. Maryland cannot force James McCulloch to pay taxes. They cannot tax the bank for doing business. Okay, that's the decision. Now, why is that important? It defines the limited power of the states. The states have no power over the federal government. Okay, we're beginning to answer that question once and for all. Who has more power, the states or the national government? It's going to be the national government. Now, that does not mean that the national government has all the power, okay? The states are still going to have some power, but that power is going to be limited, okay? And they definitely are not going to have power over the federal government. What the federal government says goes, okay? So the state cannot tax the federal government, which proves the state's power is limited and it does not have power over the federal government. The same thing is going to be kind of argued in Gibbons versus Ogden, which we're getting ready to talk about, okay? So the national government has more power than the states. That's kind of the bottom line with the importance here, okay? All right, the last case is Gibbons versus Ogden. Gibbons versus Ogden takes place in 1824. You've got two people, Aaron Ogden, who's a steamship operator, and Thomas Gibbons, who's also a steamship operator. Now, the problem is, okay, at this point in time, to operate a steam, you use steamships for trade, and they're trying to protect everybody's trade, so you only have a specific route that you can use, okay, that you can trade on. All right, so your ship can only go to certain areas. All right, and the idea is that will protect your business. All right, and to operate, you need a license. So both Ogden and Gibbons claim that they have a license to operate on this specific piece of waterway. Okay, and it was a service between New Jersey and New York. Okay, so Gibbons and Ogden are running steamships between New Jersey and New York. Both of them claim they have the license to do that. The problem is, New York had passed a law to give Ogden a monopoly on steamship travel. Ogden had a license from the state of New York. Gibbons had been promised the same thing, but Gibbons had a federal license. Okay, he had federal permission. So, who's got the license to operate on this route from New York to New Jersey? Is it the national government or is it the state government? Well, in the decision, the U.S. Constitution has a commerce clause that allows the federal government to regulate trade in interstate and intrastate commerce. Okay, so not only between states, but also within the state itself. And since the U.S. Constitution gives the federal government that power, and we'd already argued in Marbury versus McCulloch versus Maryland that the federal government is supreme in certain issues, the importance is, once again, the Constitution outranks laws in all cases. And since the Constitution gave the federal government the right to deal with interstate trade, Mr. Gibbons, who has the federal license, has the right to use that waterway, not Ogden, who has the state license. Okay? So once again, we see a situation here where the federal government has more power than state governments because the Constitution is the law of the land. It outranks all other laws. And since the Constitution gave the federal government the power to deal with interstate trade, and Ogden is the guy that has the license from the federal government, he wins. Okay? Not Gibbons, who has the state government or who has the state license. All right? Now, in all three of these cases, like I said, what you see is you see an increase in power in the federal government. The state can't tax the federal government. The Constitution is the supreme law of the land. The federal judicial branch has the power to declare laws unconstitutional. All of these are increasing the power of the federal government. Okay. Now, that does not mean the tension between the federal government and the states is gone away. All right. We're going to still see that tension as we move closer and closer to a little event called the Civil War. But the martial court is taking steps to prove to people and prove to the country that this new national government is supreme. The states are still going to have power, but in certain issues, you've got to go with the national government. The national government outranks the states in certain issues. Now, that's it for this lesson. Okay, that's it for this week. If you need to go back through and look at some things and fill in your chart, please feel free to. You do have a little quiz on this. Next week, we're going to pick back up with this theme of the national government. We're putting this Constitution into practice. We're dealing with all kinds of issues. We're going to be talking about the presidencies of Madison and Monroe next week.